Okay, I'll call this meeting to order. Hello, I am Deb Stidham. I serve as chairperson for the Kansas Behavioral Sciences Regulatory Board. I ask the members of the board to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. David Anderson.
Present.
Daniel Johnson.
Present.
Mary Jones.
Present.
Jacqueline Lightcap.
Present.
Jonna Norton.
Present.
Bruce Nystrom. Andrea Perdomo Morales.
Present.
Leslie C. Wester.
Present.
Laura Shaughnessy.
Present.
Rick Steele.
Present.
Carolyn Zaspran. Carolyn, I saw you.
Present. I'm sorry, I had it on mute.
It's okay. I note the following staff members are also present. David Fye.
Here.
Leslie Allen.
Here.
Ashley Van Buskirk. I hope
Here.
I'm saying that right. Cindy Durkel. Cindy on? I thought I saw her name. Yep, it's here. Joan Hahn. Assistants Attorney General Janet Arndt, Jane Weiler, and Laney Bernard, who are assigned to the board as general counsel, are also present, correct?
This is Janet. I'm here. I think Lainey's coming. I just don't see her on here yet.
Okay, I saw
This
Jane's
is Jane
name
Weiler.
too.
I'm present.
Okay, thank you. All right, so next, David Fye will read a message concerning this meeting being held remotely.
Thank you, Deb. And we are also using the conference call number. So if there's anybody on the conference call, if you could identify yourself, go ahead. Okay, I don't believe there's anybody in the conference call right now. So this is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the board about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the board to provide public comment or answer questions from individuals. The board will have public comment at this meeting. Individuals could request time for public comment by contacting the Executive Director by noon on March 5th, 2021. There are 2 individuals who requested time for public comment, and the total time for public comment will be limited, so the board will have sufficient time to conduct the rest of the meeting. Someone just entered the conference call. Could you identify yourself?
This is Lainey. I was having some trouble with my computer, so I'm on the phone line for now.
All right, thank you, Lainey. The total time for public comment will be limited, so the board will have sufficient time to conduct the rest of the meeting. Additionally, the meeting is being conducted by electronic means where the connection may be lost. 5 minutes for public comment is provided to the representative of the Kansas School Counselor Association. 25 minutes for public comment is provided to representatives of SIPAC, the Kansas Psychological Association, and other advocates supportive of legislation concerning SIPAC. Questions from board members do not count towards the time limit for public comment. Because we are conducting this meeting remotely by conference call and other teleconference ability, I state for the record the following information. Because the emergency declaration was issued for the COVID-19 pandemic has been extended to March 31st, 2021, the meeting is being conducted remotely to comply with health and safety concerns, as the board's conference room cannot accommodate social distancing for everyone in attendance. However, access to this meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of conference call and on the board's YouTube channel. While the meeting is being conducted remotely, the requirements of the KOMA are not suspended. As such, we will be conducting this meeting pursuant to KOMA and KAR 16-20-1 concerning compliance with the KOMA during an existing emergency disaster declaration. On February 26, 2021, we sent notice of the board meeting to all individuals who'd requested notice of the board meetings. The notice was also posted to the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting materials was posted to the board's website on the day of the meeting. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and the YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240. Each member of the board, staff, or presenter shall state the person's name and title each time the person speaks or votes. Each participant to the meeting shall ensure microphones, phones, and other electronic devices are on mute when the participant is not speaking. Each motion will be clearly stated before the board votes, and each board member will vote when their name is called. The chairperson will announce the result of the final vote. A statement or motion will clearly identify each member of the board or staff who the board delegates as authority to sign any binding document on behalf of the board. A recording of the meeting will be posted to the board's website. The board has the following items on its agenda: open remarks, agenda approval, review and approval of minutes from previous meetings, public comment, executive director's report, staff reports, complaint review committee report, professions reports, old business, new business, and adjournment. The board's agenda does not include an executive session. If the board elects to go into an executive session, the board will follow this process. First, the board must be in an open session before going into an executive session. Then a board member must make a motion to recess for an executive session that is seconded by another board member. Each board member will then vote. A majority of the board will vote in favor of the motion to exercise the executive session. The chair will announce the result of the vote. The motion must contain a statement of justification for closure and the subject to be discussed pursuant to KSA 75-43-19B, and the time and place the open meeting will resume. If a motion for executive session passes, the conference call will be placed on hold. Attendees may stay on the call or return to the conference call number at the expiration of the executive session to attend the remainder of the meeting. The public will be excluded from the executive session portion of the meeting, as the executive session will be conducted by electronic means that is not available to the public. When the board members return to the conference call, the open meeting will resume through conference call. The complete motion for an executive session will be recorded in the minutes.
Thank you, David. The meeting is now called to order, and we'll discuss our first agenda item, which is agenda approval. So if folks have had a chance to look that over, I'd entertain a motion to approve the agenda as published.
So moved.
Second,
Second.
all in favor, say aye.
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 Any opposed? Great, thank you.
And Deb, I
Moving
just want to let you know, while that was taking place, Bruce went ahead and joined, and also Lanny was able to join the Zoom meeting as well.
Thank you. Minutes approval for previous meeting. So we've got several here. So we'll start with December 21st. Any changes to those minutes? Or a motion to approve? This is the interactive portion of the board meeting.
So moved, just Carolyn.
Thank you. Second,
Leslie C. Wester will second.
all in favor, say aye.
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 Any
Aye.
opposed? Moving next to the January 11th meeting minutes. Any comments? Motion to approve?
So moved. This is Mary.
This is
Okay.
Jackie. I second that.
Thank you. All in favor, say aye.
Aye.
Aye. Any opposed? Meeting minutes for February 10th, 2021. Were those? Yeah, there they are. Any comments about those? Motion to approve?
So moved, just
Thank you, Carolyn. Do I have a second?
Second, this is Mary.
All in favor, say aye.
Aye.
Aye. Any opposed? Okay, last one, February 23rd, 2021.
Jackie Lightcap makes a motion to approve the minutes.
Second,
This is John. I'll second.
all in favor, say aye.
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 Opposed? All right, minutes approved. Okay, we are ready for public comments. Judy Huey, Associate Professor at K-State and Coordinator of Counselor Education. would you like to make some comments?
Good morning. Thank you for the opportunity to visit with you regarding ethical, legal issues, complexities. And to be clear, I'm here on behalf of the Kansas School Counselor Association, past president, current ethical chair of that committee, as well as in my role as associate professor at Kansas State. So as I'm sure you are aware, we have overlapping governing agencies for school counselors, and as well as the BSRB. Our school counselors are governed by the Kansas Department of Education. KSDE is who licenses our school counselors. They are also governed, so to speak, by our KCREP standards, if in fact they graduate from a KCREP institution. On top of that, they are governed is not the right word, but guided by the ASCA ethical standards and by the ACA Code of Ethics. So there are many layers to the governing agencies and other organizations that guide behaviors and can provide consequences for inappropriate behaviors. I suspect, and the evidence would indicate, that as we have more school counselors that are also duly licensed as LPCs, the complexities of having dual agencies provide governing responsibilities are going to become more complex. It would seem to me that if we had a policy, if we as in Kansas had a policy regarding how those violations, proposed violations or suspected violations or concerns, ethical concerns could be raised, and to whom the proper agency might be that those violations or concerns would be raised. If we had a policy regarding that, it might be helpful. Right now, school counselors are under their local boards of education. They are hired by their local boards and again licensed by KSDE. So it would seem that under their scope of work, KSDE would be the proper resource for reporting any kind of ethical concern. But if they also have a license as an LPC, then I realize that that's another layer. It appears, and I might be wrong about this, but it appears that there's not a clear policy about that reporting process. I would just like to propose that might be developed a clear policy regarding the reporting process. The same would be true for a school social worker who is not working perhaps as a social worker in a community, but is working under the Board of Education, local Board of Education as a school social worker. I have received multiple questions about that. So if an ethical concern is raised about a school social worker, who do we send that to? Does that go to KSDE? Well, KSDE doesn't license school social workers. Bsrb license school social workers. So, there's been confusion. I've received 14 questions about that since August, 14 questions. So there's confusion about what's the right way to go. And we don't want to discourage any individual raising a legitimate concern, but the proper and most effective way to report. So the last 3 days I've attended a law and ethics conference, national law and ethics conference, and I ask, other individuals from around the country, has anyone else experienced this? Are there some model policies out there? that we could review, and to be honest, no one had experienced this kind of issue. But it did come up that, in fact, there are states that are requiring now their school counselors become LPCs. And if you're not aware, KCREP, you probably are aware, KCREP is requiring all institutions with KCREP license or accreditation to go to 60 hours. Some institutions in our state or region have already gone to 60 hours. K-State is in the process of making that transition, which will again increase more school counselors to have an LPC. So I just see, I see some advantage to having a clear policy and procedure on this issue. I'm happy to stand for questions at the appropriate time, as I always say when I'm testifying before the legislature. So thank you again. I know your time is very precious. I appreciate the opportunity to share this concern. And let me just say too, all of the BSRB staff has always been so very kind and patient with our students who submit their paperwork, and with me and with all my questions and different things. So I want to say thank you to the BSRB staff. So I will mute until I need to unmute. Thank you.
Thanks, Judy. Does the board have any questions for Judy? Well, I have one. So what I'm gathering is that people who feel like they've witnessed something or been done wrong by these folks that are duly licensed don't know who to call. Is that the crux of it? Is
that it, well, so one issue is sometimes what happens is they will go to one agency or they'll go to a principal, let's say, and not get a response that they agree with. And so then they'll just keep trying to find a person to share their grievance with, or to, tell their story. Or and so I know, I'm aware of a couple of cases where that has happened. But I guess what I believe is, if we had a policy that said, if a school counselor is engaging in work as an LPC in a private practice, not with the students that he or she might be working with in school, because that would be an ethical violation. So let's say in the summer working with adults, not related to school, and a violation occurred, that would be reportable to Bsrb, because that would be in their scope of work. And as I read the statutes and tried to study the written statutes and policy now, the definition of LPC and Bsrb regs is very specific to LPC. And so for a school counselor who is not working as an LPC in the school setting, not getting third-party payments, strictly working under their Board of Education policies and procedures, it would seem that the Bsrb definition of an LPC would not fit for that school counselor, but in fact, KSDE board policies would fit, and their local board policies would fit. And so it seems to me that it would be all about their scope of work and contract on where that grievance should be filed. I don't know, that's my thought. Does that answer your question?
Mostly. I mean, I think there's got to be some sort of precedence. I mean, I don't know how common it is, but we certainly have people who are licensed by the Board of Healing Arts and with us, I'm sure. Again, I don't think it's a large proportion of people, but so there's got to be some precedence. And I think when you consider protecting the public, depending upon the nature of the offense, I don't think we'd want to certainly turn a blind eye at the BSRB just because they weren't technically working under as an LPC. And that definition, frankly, is maybe a little broad, at least in my understanding of it, a little broader than what, because even things I do in my personal life, or if I get arrested or whatever, can certainly affect the BSRB's handling of my addiction counselor license. So, you know, it's complicated. That's why we have attorneys, right?
Right.
But I agree that there probably could be, because it's not a lot different than addiction counselors working in licensed KDAD's facilities, because they have some jurisdiction that's different than ours. And so really there needs to be coordination, there needs to be communication. We need the opportunity to review the information to say this either does or does not fit under our statutes and regulations. But there has to be some sort of communication. So, you know, policies are usually never a bad idea. So, and we don't usually have enough of them in our everyday life. But so I certainly can agree with some of that. So it's a complicated.
And I agree with what you just said about there absolutely would be some areas where, you know, a violation
need to
would
know.
absolutely go both,
Yeah.
yes,
Yeah.
be applicable in both agencies. Absolutely,
Yeah.
I agree.
Yeah. But coordination of care and that communication, again, that's something we've striven for over the decades, honestly, with KDAD's facility licensure, just to say, do we are aware of what each other, what's happening, and do we need to take action, or is it not appropriate or applicable in this case? And then we just defer either or. So, yeah, great. I really
I have a
appreciate you
question.
coming. Yeah, go ahead.
Judy, are you aware, do some school counselors get licensed by BSRB but not practice as a counselor as you suggested?
Yes, actually, at this point, probably the majority are like that. I think that may very well change. At this point, probably the majority do not have a private practice. Again, you know, I suspect that will change in the next few years. I think many are licensed. Well, I tell my students it's all about options. I encourage them. I encourage them to be licensed. I think it does give them options, but I think it also increases their knowledge and skill base, which is, you know, very, very important. And I think in the very near future, they will want the option of engaging in setting up a private practice. But I stress, and I know I speak for all counselor educators across Kansas, you know, you can't have a private practice with anyone that is in your school district, associated with your school district, you know, that you don't do that. But portability is such an important issue. And hopefully we will see some change. I know ACA is working feverishly to try to increase portability. And KCREP is working on that as well. And that's an issue in our programs, particularly in our PhD program, we are working on now with COVID. It is, you know, it's become an issue. And I've spoken several times with KCREP about our practicum students, and you know, they're just getting hours. And so it's an issue.
It just seems
I
to,
think it's going to change pretty quickly.
it just seems to create an issue for us if they are asking to be licensed under the BSRB, but not in your situation really having distinct roles between their school setting and work and a private practice. So whereas that would make it somewhat easier if they're only serving as a school counselor but are licensed under BSRB, it's pretty hard for us then not to be, I think, involved in an ethical complaint.
this is Cindy, and I'm the special investigator. And just maybe another viewpoint is we have a significant precedence for with the school social workers. Example would be a dual relationship with where even if it's in the school, it would still be a violation of the statutes and regulations of the state of Kansas to have a relationship with that student. It affect your objectivity. And so it's really hard without an investigation to understand where it's limited to the confines of the school, as perhaps you said the policy would be, or whether it's limited to their outside practice. And so another way to look at it is that we look at it is that if you're our licensee, we would first look at it as that we have jurisdiction over you. And then we would determine by looking at that person's conduct, whether it's outside of the statutes and regulations. But a really simplistic way to look at it is if you're licensed with us, you are licensed with us. And that's a more simplistic way of what Dave was saying. But then we'd look at, after an investigation, if that conduct, if we had jurisdiction over that conduct, instead of just looking at the person and what that and splitting it out that way. So it's really hard for us to make that block on where their workplace was, whether we had jurisdiction over them. They have a license, and that's how we look at it. But we have a significant amount of experience with school social workers, because to be a school social worker is a protected term. And to be a school social worker and call yourself a social worker, you have to be licensed in the state of Kansas.
And KSDE and the American School Counselor Association would say that about a licensed school counselor, that in fact, licensed school counselors are licensed under the KSDE. And so, you know, there's probably a difference of opinion there.
Well, and again, going back to alcohol and drug facilities, those questions have been raised to the Attorney General before to issue opinions, because you're right, sometimes there's just laws created that there is no easy answer. But in the meantime, I mean, I think the question is, how do we reduce the confusion? So just to get to the crux of it, and then we probably need to move on. Is it consumers don't know the process? No one knows the process. It's been problematic once the process is actually started as to who has what, or what communication can be had between the parties. What is it? All of it?
Perhaps all, yes, I would say perhaps all of the above. Jurisdictional issues for licensed school counselors. Yeah, I think
it's going to come down to both parties have jurisdiction. So we just have to figure out how to work together.
Yeah. Yes,
and again, for the public, you know, good, for protection of public.
Absolutely.
I think both sides would want
always.
that to, I mean, we wouldn't want somebody to slip through the cracks because they, you know, well, it's not exactly what I was doing. So I think we would all be up in arms in some situations. So
absolutely.
Do you have a recommendation for a next step for the board to consider?
Perhaps just reviewing current policy and procedures, and if there are gaps. I mean, it seemed to me that there were gaps, but again, I might have missed something. I don't, you know, I might have missed something. But regarding, I'll take the school counselor as an example, but there might be others. The relationship between the scope of work and the process and procedures for reporting concerns. Who has, who has that jurisdictional, maybe the first step in the jurisdictional process, or how that communication should occur. I would leave that up to you, but I think that a review of current policies and statutes, and then to consider, are there gaps that it would be helpful to address and to be more specific, and maybe working with, I don't know, KSDE or with school administrators. And I don't speak for school administrators ever. Licensed as a school administrator, actually, but I don't speak for administrators in Kansas, but it would seem to me that they would have a voice in this process as well. So just some ideas.
Okay.
May I ask, is there some reason though why they don't file a complaint with the Board of Education and with BSRB so each can start their own investigation to make a determination if it is under their jurisdiction? I mean, because if you file it with one and they investigate it for a couple months and decide it's not under a jurisdiction, then the other one is not doing anything until someone files something with it. So I don't know what there is to prohibit them from filing with both boards.
Well, I think that in a couple of cases that I'm aware, and again, these are just, I'm going to speak generically. Sometimes what happens is a disgruntled, I'll just say parent, a disgruntled parent perhaps doesn't like the decision that was made by the board or by the administration. And so they look for other recourse, and the BSRB is that other recourse. So they, it's kind of like an appeal process, maybe. Yeah, when they're not satisfied with the first decision, they go to another avenue.
I don't think there's any way that I'm sorry, didn't identify myself, but I'm Janet Arndt, the Assistant Attorney General for the board. But I don't think there's any way that we can stop someone from filing another complaint with us, though, just because they were unhappy with what they got from that other prior decision by someone else. Yeah,
Just for my clarification, Judy, when you say they're not satisfied the answer they got from the administration, are they filing a formal complaint against the license, or is that more of like any employer, I'm unhappy, I wish it would have went different, or they didn't have a good attitude, whatever, or is this actually a formal process that they're doing against the license?
I believe that they are attempting to do a formal process, or at least expressing themselves in a complaint.
So when you're saying there's a decision made by the administration they don't like, this was as the result of a formal investigation and a response against whatever those rules and regs are against that license.
Mm-hmm.
Okay.
Mm-hmm.
Reading between the lines, I guess I'm wondering if it is your feeling, having known some of these cases, and I don't have any sense of the volume one way or the other, of legitimate cases of complaints versus more frivolous, I'll call them, that the involvement of the BSRB is not necessarily needed and is some way an adversarial action against the potential LPC. Like it's just gone too far, it's just not needed. I guess I'm trying to figure out what's behind some of this.
It appears that way to the school counselors. It appears that way to the school administrators, simply because the school is aware of the backstory, and perhaps that maybe and we all know individuals are aware of individuals that, especially during COVID, I'm going to say, have their stressors, their mental health coping skills are not working very well, and consequently they are lashing out, and maybe they've lashed out at grocery stores and other individuals in the community and the school, and so this is maybe the their fourth avenue, and their facts, the facts that they're submitting are not factually correct even. And so it's just, one more thing that school counselors are having to address, and school administrators are having to address, and attorneys are, needing to be involved. so for our school counselors and school administrators, it's like, oh my gosh. Now, I separate that from what at some point and what I might not ever be aware of, very perhaps legitimate concerns that are raised. And that's totally, I don't ever want to say that legitimate grievances should not be shared, or concerns with KSDE, local school boards, and administrators, and BSRB. Absolutely. When there are ethical and legal issues, whether it be a school counselor, administrator, or a social worker, school psych, whomever, always should be shared and reported. So the goal is not to diminish reports. It is, though, to make sure that there's an effective and efficient way to submit. And I think someone said communication. Maybe that's the goal, is to have good communication so everybody's on the same page.
Mm-hmm. Okay. Well, I appreciate your comments and all your information. Any other questions from the board? Okay, Judy.
Okay. Thank you so much.
Have a great day. Yeah.
You too. Bye.
All right. I think we are ready for our next group, and I'm not sure if all the folks listed plan to speak. Janet Orwig, Whitney Dameron, Bud Dale, Katie Kreigsheiser, Teresa Cuddington, or if someone is going to be a primary spokesperson, or.
Madam Chair, this is Whitney Dameron. If I could interject for a moment, I'm Governmental Affairs Counsel for the Kansas Psychological Association. Appreciate the opportunity to address the board and you, and for David making this accommodation, working with Leslie as well. Janet Orwig is on.
Whitney, can I interrupt you for just a second? This is Bruce Nystrom. As this conversation begins, I have to recuse myself from this conversation because of my potential conflict of interest in my roles with KPA and with BSRB. So I will recuse myself and listen very carefully. Thank you.
Thanks, Bruce. You can go ahead, Whitney.
Thank you, Bruce. Quickly, rather than dwell upon kind of things in the past, I'd like to set the stage for where we're at, look forward, and then turn it over to Janet Orwig. I know she has a limited amount of time today, but kind of where we are now, there's a Model Act SIPAC bill that has passed the House on a vote of 121-3. It's moving to the Senate, will be considered in the second half of the session. We made a request to the committee that worked it in the House, given concerns expressed by BSRB about implementing this legislation this year, to delay implementation to January 1, 2022. Under SIPAC, the state, should this legislation pass, would have an additional 90 days to appoint a representative. So we're looking at April 1, 2022, kind of for a firm implementation date. In a letter of transmittal I sent over to Director Fye last week in response to questions that the BSRB expressed to the legislative committee, is that KPA wants to work with BSRB on implementation. We're willing to work if there's changes to the bill this session, or even in 2022 session, if they can be accommodated under SIPAC rules and regulations. It is a model act. It has passed in 15 states, including the 4 states surrounding Kansas. It's under consideration in another 14 states, including Kansas, as well as the District of Columbia this year. So SIPAC is happening. It is going to be implemented around the country in broad sense of the terms. We believe Kansas should make preparation to be involved, and that's why we want to pass this bill this year and not delay. And so with that, I'd really like to, with the chair's permission, to turn it over to Janet Orwig and let people talk with her because I know she does have a limited time. And thank you very much.
Yes, that would be fine. Janet?
Oh, good morning. Thank you for your time today. I really don't have any set words or statements. I really was just going to be here to answer any questions that you might have. So I don't know if there's others in my group that want to talk first, or if you have a series of questions. I would like to state that we are, as Whitney said, have legislation in 14 other states. We do expect the District of Columbia to go into effect on March 19th. I don't know if everybody's familiar with the process for DC, but the council approved it, the mayor signed it, and once DC that happens, it has to go sit for 30 days at the federal level on a desk somewhere up there. And it has been sitting there waiting out its time and should be finished on the 19th. So we could have 16 states by the 19th. The other jurisdictions or states that have legislation going right now have seen pretty good progress. We have either passed out of one chamber or another, I would say, in the majority of those. So we are seeing a little more movement than we did last year. We had a lot of legislation last year, and then, you know, with the way the world went, we got shut down in a lot. We felt very fortunate to have actually gotten 3 states through last year. We got Pennsylvania, Virginia, and North Carolina, which just became effective on March 1st. Even though it was enacted last year, they had an effective date of March 1st for this year. So they just came on officially on the 1st. So, but I'd be glad to answer any questions.
Board have any questions? I'm hoping the board had an opportunity to review the information provided, where, not sure exactly who wrote it up, but Mr. Dameron and Ms. Ortig wrote up responses to the concerns that we had asked David Fye to present in our opposition testimony. So I guess hearing no other questions from the board, I think it would be helpful for some of us that haven't frankly studied this for very long until it came before the board. So as usual in legislative session, everything is in a kind of a fast tempo. And we certainly want, you know, we're trying to do our due diligence here to understand fully the issues. One of the issues that we raised was that we were concerned that consumers would not know who to complain to and or how that process would work. And so since there is precedence in other states, I think that's helpful. You know, it's not like we're the first state or anything. So how has that gone? What is that process? And I think it's interesting that this is kind of the same conversation we just had with Judy in a slightly different way. So if someone wants to respond to that, I know you provided the written didn't really, it's not very clear to me. So whatever that's about. So maybe that might be helpful for the rest of the board.
Okay, I'll be glad to address that. There's several ways. One, in regard to how the psychologist sets up their practice with the individual client as part of the informed consent, they would be explaining how they are practicing with them via the PsyPact authorizations. They provide them information with not only how to contact the licensing board where their home state is, but also the licensing board where that client is, and explains out to them in that informed consent how that is to be worked out. There are several sample organizations that are providing informed consent samples, one being the Trust, which is one of the largest insurance liability for psychologists. So they do provide resources for their insureds. And so that has been very helpful with the information they have been providing. In addition, the compact rules have spelled out how the states would work together. It is the requirement of the home state to be the main responsible for the investigation, since that has the authority of the home state license. But the receiving state, or where the patient would be located, also has the ability to do a cease and desist or an injunction. And that we also, the commission established rules that would allow for a joint investigation for the two, which they may not have currently right now. One of the things I think is really interesting is one of the states that came on to SIPAC came on pretty early. And because of this issue, they had 2 psychologists that were practicing via telemeans into their state. And this was prior to SIPAC, and they got into, did something that the person complained to the Arizona Psychology Board, because that's where the person was located. And the Psychology Board realized that they didn't have any authority to do anything on that because the people were in another state, and they contacted that other state, and that state didn't have any authority because the patient wasn't in their state. So the commission was very much aware of these and tried to write into the rules the ability for the states to work together and how to address that. So between the informed consent, the consumer gets the information, and then the rules have laid out the disciplinary process for the states to work together.
Okay. Can you speak a little bit more to how that joint investigative process might go?
Okay. Once the complaint is filed, so let's say if someone is practicing into Kansas and you are the receiving state, you are, like I said, could do a cease and desist, and that information can be sent to the home state, and the home state can start their investigation. One of the issues that came up a lot was how would you handle subpoenas? And if you weren't here in the home state trying to get information from that. So it was written in the rule that would allow Kansas to actually issue the subpoenas for the home state if that was necessary. It also allows for the sharing of information between the 2 states, which right now might not be available as part of the way your rules and public released information is allowed. So that does give that ability for them to share that information. They can do 2 separately, or they can work together. I'm very fortunate, and I kind of always hate to put this out into the atmosphere. We have not had that happen yet. So always a little scary to say something. Sometimes that opens up a door I didn't want to open, but right now we have not had any of complaints come in.
I have a question.
Okay, go ahead, David.
So in states that have implemented SIPAC, can you talk a little bit about changes that have needed to be made to the regs and statutes in that state to accommodate it?
Currently, most of them have not had to make any changes into their regs. There has been some language added to the not the 4 corners of the document of SIPAC, but at the bottom to reference back to, let's say, if you have something in your statute that says not practicing without a license. They have had to go in and said, or except practicing under SIPAC. Some states have had to do that, some states have not. They felt that it was part of just the way the compact worked, it wasn't necessary. There has been, I'm trying to think something else that was put in there recently, dealt with making sure public notice was done. And that is part of SIPAC does have to, the commission has to provide public notice, just like a licensing board does, but they wanted to firm that up. And so they put a little bit of language at the back end of the 4 corners of the document to address that. But mostly has been something referencing back something in a law that just to firm up what SIPAC would cover. So like I said, opening, the public relations as well as what would be an exemption for licensure just if that's needed.
And what about the, can you speak to the obligation of the person wanting to practice in terms of their responsibility to understand the regs in the state, like if they were going to practice via telehealth in Kansas, to understand those regs?
Okay. As part of the acknowledgement that the applicant fills out for their certificates, they do have to acknowledge that they will be aware of and abide by the rules and regs and statutes of the state in which they will be practicing into. They also have to acknowledge that they will be familiar with the telepsychology guidelines that were drafted by APA, ASPPB, and the Trust, which spell out a little bit more about how the differences between a telepractice and a face-to-face practice. And so they have to be very much aware with that, but they do have to attest that they will be aware of the rules and regs and the statutes into the states that they'll be practicing into.
Thank you.
Mm-hmm.
Madam Chair,
Yes.
this is Teresa Coddington. I also wanted to let the board know that Dr. Katie, who is on this call, does have an e-pass. So she is part of SIPAC in Missouri and has a Kansas license. So if you have any direct questions, Dr. Katie does currently have an e-pass.
Thank you for that. Other questions from the board?
Yeah, this is Rick Steele. One of the questions I've got is how many psychologists from out of state would be expected to be practicing inside Kansas?
Okay, we recently, so with the 15 states we have, the total number of licensees that are, if you combine all 15 states, is right around about 38,000. Now that could mean that they're being counted double because I can't tell if you are licensed in 3 states, you're going to be counted 3 times. So, but if I look at each of the states and do it that way, based on the number of authority to practice interjurisdictional telepsychology that we have issued, which is right at 17, a little bit under 1,700. I think we had figured it was under 5% of the people that are actually eligible to come in have been able to, are doing that. So it's not a huge number, even in this COVID world, that you would expect to see based on what we've been seeing by the people that are applying. That also includes due to a HRSA CARES grant, we were actually able to waive the e-passport application fees through January 31st. So we had a huge influx of applications and still didn't see, you know, like everybody in that state applying. So it still was very limited in the number of psychologists that felt that this was something they wanted to pursue.
All right, so there was a lot of numbers there. So that you said 38,000 have an e-pass.
No. 1,700 have an e-pass.
Okay, what was the 38,000?
The 38,000 is the total number of licensees in those 15 states that are SIPAC states.
I see. So 17,000 psychologists.
1,700.
100.
1,700.
Okay.
Janet, can I ask you to explain a couple differences that there are with other medical compacts, medical provider compacts? I noticed that here, if I'm understanding this correct, is that when an individual wants to have the SIPAC license, which is often referred to as a multi-state license, the application is not filed in with Bsrb if Bsrb is the home state. Is that, I mean, Kansas is a home state, is that correct?
That is correct.
That's something that's not the way it's done in other medical providers, because licensing is typically looked at as a police power of the state. So the state regulatory board makes the licensing decision. Is there some reason why that's different for this particular compact?
Actually, medicine is the difference of everybody else. The other compacts have been set up somewhat similar. Medical is considered an expedited license. So you are actually still applying for license in every single state and maintaining licensure in all of those states. So that is kind of why it is set up that way. The remainder of the compacts have been set up where you have your one home license and you get privilege to practice into those other states. As part of being represented, each licensing board gets to pick who would sit on their commission. And so that person sits on the commission and would represent Kansas as it goes forward. But as far as your licensure components, you're still licensing your psychologist. It's just that you would be allowing these other psychologists a privilege to come in and practice via telemeans. The other compacts, while we're still a little different than the other ones, is that they are a little more open and you would be able to come in and have a full practice via those privileges. And SIPAC is very limited to the telepsychology component, as well as just a 30-day in person to come in and do testimony or something like that.
That was set up based on feedback from the Association and State of Provincial and Psychology Boards members, which are all the licensing boards across the US and Canada. And they really just wanted, based on my earlier example, assistance with how to handle the telepsychology component. So we are a little bit less than the other compacts, but we are not set up the way medicine is. We have a certificate for professional qualification in psychology, which aids in getting a license, and felt like that addressed the expedited license component. So that is kind of why we set it up this way.
And then like the other compacts, if it occurs, the conduct occurs in Kansas, even though their license is somewhere else, if they're part of the compact, the regulatory board can go ahead and suspend or revoke the privileges to practice in that particular state. But you're not using that language, you're using a cease and desist. Is that correct?
A cease and desist or an injunction will suspend or actually will revoke, because part of SIPACT is you cannot have any disciplinary action. And so if you do a cease and desist or an injunction, that's going to revoke their privileges, as well as any of the certificates that have been issued.
Thank you.
Mm-hmm.
Other questions from the board?
This is Mary. I'm sorry, I was trying to read through the documents just to see if I could find it before. I understand there's some standardized agreements that the providers are subjecting to. Is that specific to the consumer, what exactly they have to disclose to the consumer, even in terms of how to, beyond filing a complaint, but how to get copies of their records and more part of treatment type coordination with external providers, for example, those kind of things?
My understanding on some of the informed consent, there's the standard that they have now that's just regarding face-to-face practice and all of that is covered. The recommendations from the telepsychology guidelines, which cover strictly the differences, would address those. So let's say we're having a session and we go down 10 minutes into the session. How does that happen? How do we get back? What are the contingencies for that? What would be the billing address with that? So those things are still going to be also spelled out in the informed consent. The additional things you do for a face-to-face practice, plus anything that is specific to the telepsychology component.
Any other questions?
I might be a little, I'm just not understanding exactly how this is formatted, but essentially are the regulatory boards among each state agreeing to, by contract, to collaborate on investigations together? In other words, what's the force, the legal force that says Missouri has to work with us when we have an investigation?
That is the part of the beauty of an interstate compact. What it does is it creates the contract between the states, and then by putting it through the legislative process, that creates the force. So the contract is kind of the language of the compact itself is the contract, but by putting it through each of the legislative processes, you've created that force behind there. That's also kind of why the language needs to stay similar, because you've all agreed to the same contract.
Did that answer your question, Mary?
Yes, thank you.
Yeah. Other questions for our guests?
So I have just one quick question. So the home state would still be, after the investigation, the home state would still make the determination of what level of disciplinary action or any type of corrections that would be made. Is that accurate?
You would be making the decision on their license, where the receiving state can do a cease and desist and say, you cannot practice in here anymore. You would be deciding what, if anything, would be done to their license. Yes.
Thank you.
Other questions? Okay. Hearing none, I think, go ahead.
Madam Chair, members of the board, just in closing, it seems like we're wrapping up on Q&A. Again, I want to reiterate that the Kansas Psychological Association is committed to working with the director and the board on this matter. I think we have, it sounds like a little more than a year if we need to work on changes or at least get people on the same page on how this works. We offer resources, people working back with the board to ensure a smooth transition. It's not as if Kansas would be the first state. There's significant resources around the country with what's happening in other states, and certainly the 4 states surrounding Kansas that already have PsyPact, and I think a number of licensees that are already taking advantage of this on the border, probably in particular Kansas and Missouri, like Katie would acknowledge. And I think this is very doable, and I think the people of Kansas would benefit from this, and we can do it in a safe manner that if we all work collectively together. And appreciate your time today and remain available for response. And Janet has been a tremendous resource, and I know she's committed to working through with the state of Kansas as well.
I had one follow-up question. So we've got these 15 states. How far back does this legislation go? How many years have we been having these kinds of arrangements?
So Arizona came on first in 2016.
Okay.
A compact has what we call a magic number, how many states you have to have enact the legislation before you can actually become effective. For PsyPact, our magic number was 7. So when Arizona enacted in 2019, April of 2019, they became state number 7, and then we were able to get the commission together and do the bylaws. So first state was in 2016, and we actually got up and going in 19.
Okay, all right. All right, last call for questions or comments. All right, hearing none. Thank you very much for your time today.
Thank you.
And the board will certainly be considering all that you've told us.
Thank you very much. Appreciate it.
Thank you. Okay, we have been at it for an hour. Does we incline for a break? Let's push on.
I'm good to keep going.
Okay. See, you got to speak up quick around here. All right, let's go back to the agenda. Executive Director's Report.
All right, thank you, Deb. This is Dave Fye, Executive Director for the BSRB. Things have been very busy here over the last few months, so I will try to condense as much as possible, but I have a lot of updates for you. First, since the last regular meeting of the board back in January, former BSRB Executive Director Phyllis Gilmore did pass away on January 24th. She had served as Executive Director for the board for about 10 years, right around from about 2000 to 2010. I went ahead and sent flowers to her funeral on behalf of the board, and her obituary is listed on your report, so I thought it was a nice amount of information. So. In terms of another agency update, I wanted to let you know the meeting the board had back on the 23rd, the board passed motions to allow us to go ahead and contract with experts for the review of certain applications. There are certain individuals who obtain their educational criteria for licensure from institutions that are not accredited by the national accrediting organizations. And when that happens, it's a different process we have to go through in terms of collecting information and having that review done. So board members are allowed to do the comparison, to look at the information to see if the educational criteria matches the Kansas requirements. However, if an individual on the board doesn't have that background or that formal process that they are familiar with how to do that process, we wanted to allow the board to be able to contract with other individuals to process some of these applications and submit reviews. So there were some professional counseling applications. And since that meeting on the 23rd, we did contract with Gary Price for the review of some of those applications. Gary is working on reports and submitting his recommendations for the board to review and then make final determinations at CAPA sessions. At least one, if not more, of those are going to be available for the CAPA session that'll be on the 10th. And then I believe more should be available for the CAPA session that is planned for the 15th. At the meeting on the 23rd, there was a question in regards to determining who would be contracted by the board. And so basically under the current authorization, since the board members have the ability to make those type of reviews, we wanted to clarify. So if there is a application that needs to be reviewed in this kind of manner, we would initially go to the board member representing that profession and then any other board members who sit on that advisory committee to make sure that there were no objections to the individual to providing that level of review. So that's what the process will be following. So I want to let you guys know that, clarify that process. Also, in terms of another agency update, follow-up from the January 11th meeting. So at the January 11th meeting, that was the first time that we were able to broadcast meetings to the Bsrb YouTube channel. Since that time, we've been able to broadcast 4 advisory committee meetings and 3 board meetings, including this one. We had a technical issue with one of the advisory committee meetings. However, we were able to save the audio. And I went ahead and took that and bonded it to an image of the Bsrb logo and create a new video for that meeting. And we went ahead and uploaded that to the Bsrb YouTube channel. So now all the meetings are covered. In terms of views, we currently average about 15 views per meeting and we have 3 subscribers. In terms of the Bsrb bills, at that January 11th meeting, there were recommendations for statutory changes. I'll be addressing those a little bit later, but that was one of the follow-up items from that meeting. Also, in terms of the January 11th meeting, there was a request to look into the background on KSA 745374, which concerns disclosure to a client to begin of a client-therapist relationship. And that item, I was able to pull some of the legislative history behind that statute, and that will be discussed later on in the board meeting under old business. In terms of just some operations updates from the board, from the agency, in terms of the application processing. So currently we have a number of computers in the office that are past their warranties and the staff have been experiencing some problems with delays related to using the older technology. So we have contacted the Office of Information Technology Services. In the budget, there is money to go ahead and do some cycling and replacing of computers. So we went ahead and agreed to replace some of the current desktops with some laptops and docking stations. And so we're going to start with 3 this fiscal year. And then if that works out great, we're going to reconsider doing that with some additional ones in the next fiscal year. So we're starting to get some better technology, which should increase our functionality. Also, some of the employees' roles in my time with the board or the agency, it appears that some of the employees, based on their job duties, would be helpful to have in the office a little more frequently than what is the current situation allows. When I became part of the agency under the pandemic, we had a lot of our staff members working in the office about 1 or maybe 2 days per week, and the rest of the time they're working from home. Now, of course, I want to maintain the safety of the employees, but in certain circumstances, I think it would be valuable for us to have employees back a little more frequently than just the 1 day. And so I had made a request to the Department of Administration and the Department of Emergency Management Services to try to get staff back in the office, in a phase-in approach, maybe just instead of it being 1 day, let's start with 2 days. I was strongly discouraged from implementing that currently based on the current situation, which, like I said, I don't want to do anything that would jeopardize the health of the employees. However, they did say since the vaccines are being rolled out now, they would ask that we wait just a little bit longer before considering something agency-wide. But they did say on a case-by-case basis, if individuals can be moved back in and they have to be because of their job responsibilities, on a case-by-case basis, we can evaluate that. So that is what I've been doing, moving slowly, but in terms of an office-wide policy change, we have to wait a little bit longer. And then just in terms of overall application processing, I wanted to let you know I've been doing an evaluation of some of the processes here in the office, and the staff are working very hard to process applications. But I think that there are some systematic changes that I'll be considering over the next few months, and I just want to give you like a heads up on that. The process for reviewing applications has a lot of specialization here in the office, and when everybody is in the office every day, that functions in a certain way. But with the pandemic and the possibility that we might have more working from home in the future, I think some coverage and some different ways of approaching the application process would be valuable. This is not something that's going to happen overnight, but it's something that I anticipate rolling out over the next few months in a different way of processing. Also, when individuals need to take time off, it's kind of a complicated thing when there's so much specialization, because if you leave and come back, you have a pile. And so I want to make sure that we're providing good customer service, processing things quickly, but I want to let you know that these things will probably be looked at and changing over the next few months. In terms of our customer service, we're trying to look at improvements. I think we can make some improvements in customer service. The staff is very polite to the customers. However, we have a technological issue that we're currently trying to deal with, and that staff are not able to make outgoing phone calls when they're working from home. This is a limitation because when we have our office phones when they're in the office, but at home there's a limitation. I have been meeting routinely with the Office of Information Technology to try to solve that issue. Initially, we thought we might be able to have employees take their desktop phones home. However, when we looked more into it, this was not something that we could use. We were told there might be some soft phone technology, maybe using Teams to go ahead and make phone calls from home, but this was a dead end. I did some independent research, looked at maybe providing some Skype phone numbers to employees. They could do this temporarily, but that had to get approval because there was some information to be downloaded on the computers. And then just this last week, when I asked them again about the process, they indicated that they are rolling out Jabber technology on computers for employees. So this should allow us the ability to make outgoing phone calls, hopefully soon. I submitted a ticket to the OIT's office and asked them to go ahead and make the necessary downloads, and also put in a purchase order to purchase some headsets, which should allow for this too. So I want you to know that I'm looking at this and we want to make some improvements. We're working with the technological limitations that we currently have. In terms of office safety improvements, we've been trying to manage our supplies in terms of PPE for employees. We were starting to run a little bit short on masks, so we went ahead and contacted the Department of Emergency Management Services, and we were able to obtain some additional masks for employees. And we have some in the office. Should we go back to any kind of in-person meetings, we should be fine through at least the end of June, if not past there, depending upon our rate of usage. There are other supplies we're in good supply of, so we're in good shape there. In terms of other office safety improvements, there were some ceiling panels that had some water damage. I felt like it wasn't a great environment, so we went ahead and talked to facilities. They made some adjustments there, so I think it's safer in that regard as well. We were also having some hot and cold temperature issues building wide, and with the very low temperatures we had, that was going to be an issue. So we talked to facilities, and they were able to resolve that as well. And back in January, we had the inauguration at the federal level. The building had to be shut down for about a week. Thankfully, I just wanted to let you know that it seems like it was precautionary, and I'm not aware of any kind of issues we had here in Kansas relating to safety. In terms of the COVID-19 vaccine for Bsrb staff, so right now the state is providing vaccines for state employees. We are currently in phase 2, but we are moving to phase 3 very shortly. Phase 3 is where the remainder of state employees will have the opportunity to take the vaccine. We do have the authorization to go ahead and provide some leave for individuals to go ahead and to get the vaccine. And then if they have any issues in terms of side effects, we are able to take care of the employees in terms of time away from the office for that. But we're also letting staff know that according to the instructions we received, staff are not required to get the vaccine, and we're not allowed to, we're not supposed to track that. So we make it available, we'll get the information out to them, but that should be coming up here shortly, sometime hopefully in the next month. In terms of legislative updates, I'm going to very briefly summarize the budget actions. So our budget was heard by the House Higher Education Budget Committee. There were a lot of questions. Our budget was the first one up for that budget committee, but we answered their questions. It actually advanced out of the budget committee favorably with no changes. Went in front of House Appropriations. There were no changes. It was passed favorably. There was one member of the legislature objecting to it, but it wasn't specific toward the Bsrb budget. It was more about the process of moving the budgets through the committees so quickly. So I wanted to clarify that in case you had heard any issues about that. On the Senate side, the budget was heard in an unusual process. Usually it's in a subcommittee dedicated solely to budgets. This year, some of the budgets were heard in standing committees. And so the budget was heard by the Senate Transportation and Ethics Committee. They asked some questions but didn't make any changes, and then it was reported out Senate Ways and Means with no changes. So unless there are things affecting all state agencies, I think the budget for the BSRB was able to pass through with no changes. So in terms of other legislative updates, the action on the BSRB bills, which was House Bill 2208 and also Senate Bill 238. First, when I spoke to you in January, I was anticipating having one bill submission, and that was going to be to the House Health and Human Services Committee. But in talking to members of the legislature after that point, there were some concerns that if there was an outbreak of the COVID-19 pandemic, they might have to either the House or the Senate might condense its time for budget hearings greatly, or potentially they might have to shorten the entire session. So they wanted the flexibility to be able to work on it at the same time in both committees, or at least have the option that one could go forward. So I went ahead and requested the same language from the House Health and Human Services Committee and also the Senate Public Health and Welfare Committee. Both bills were presented. I requested hearings in both committees, and there were hearings. And in the House Higher Education or House Health and Human Services Committee, the hearing on the bill had 11 individuals with proponent testimony, one with neutral and no opponents. While the individuals were speaking in favor of the bill, they requested a couple changes. One was to remove the language on board certified clinical supervisors for social workers. And the language in the bill also included a reduction of the direct client contact hours as part of the practicum for social workers from 350 to 200. Some individuals who provided testimony requested that this 200 number be cut out entirely and there not be a number of hours specified in the practicum. When the bill was worked by the committee, they went ahead and took both of these and adopted them as amendments. They also removed some language in the bill that would have set the cap on the supervisor position at $50. And then they also amended in language from House Bill 2206, which involved telemedicine. And then the bill passed favorably for passage out of the committee. When it was worked on the floor, there were two individuals who spoke in favor of the bill. The bill passed the House on a vote of 124 to 0, and it has been assigned to the Senate Public Health and Welfare Committee. On the Senate, Senate Bill 238 had a hearing. At that hearing, there were 12 individuals who presented proponent testimony, one who was neutral, and one who presented opponent testimony. When the bill was worked, they adopted the two changes that the House had made in regards to the social work modifications. They also amended in the language of House Bill 2206. They made one unique change, and that was to add in the language of Senate Bill 138, which involved certified community behavioral health clinics. And the bill was renamed Substitute for Senate Bill 238. And then on the Senate floor, it was carried by Senator Hildebrandt. There was a technical amendment to adjust the implementation date for the CCBHCs from July 1st of 2022 to January 1st of 2022, but nothing that affected the language for the BSRB items. There was another amendment that was proposed that would have added Medicaid expansion to the bill. There was a lengthy discussion on the floor, and during that discussion, it was noted by a couple members that this was due to an agreement to allow the Senate to have a discussion on Medicaid expansion when the hearing was, or when they were working this bill on the floor. They took a vote on the Medicaid expansion amendment, and the vote on that Medicaid expansion amendment failed on a vote of 12 to 23. And then overall, the vote on the bill, as it was passed by the Senate, was on a vote of 38 to 1. And the bill has now been assigned to the House Health and Human Services Committee. So now that the bills have passed each chamber's floor, the language relating to the BSRB is identical. However, since the bills are different, I'll be working with the chairs of both health committees and trying to get those passed, or at least passed on one side. And then I wanted to give you a summary of some bills affecting the BSRB. One was House Bill 2206, which I spoke about back on the February 10th meeting. It involves telemedicine. That bill has been amended into both of the bills relating to the BSRB. Second, House Bill 2207. This was a bill prohibiting conversion therapy to minors. And this bill was in the House Health and Human Services Committee. It did not receive a hearing. Generally, in circumstances like this, that means the bill will stay in that committee and not be worked until next legislative session if it is worked at that time. The next bill is House Bill 2209, and that was the SIPAC bill. And the bill was amended, as Whitney Dameron spoke about earlier, to change the implementation date from July 1st of 2021 to January 1st, 2022. It passed out of committee, and like he said, it passed the House floor in a vote of 121 to 3. In terms of some general regulatory bills that would affect the BSRB in terms of affecting most regulatory agencies, I want to give you a heads up about a few of these and where they currently stand. First one is House Bill 2370. And this would be a bill prohibiting criminal conviction from acting as a sole disqualification for an occupational license. This bill is in the Senate, is in the Commerce, Labor, and Economic Development Committee. It was scheduled for a hearing, but it was canceled, and so I believe this bill will stay in the committee this year. The next bill is Senate Bill 10. This would have enacted a Right to Earn a Living Act, and it would have required regulatory agencies to complete a comprehensive review of all of their statutes and regulations, and then they would have a year to do that. And then if there were some that did not fit a set criteria for keeping those regulations or amendments or statutes, then the agencies would have to go about a process of eliminating those from either the statutes or the regulations. This bill did receive a hearing, but it wasn't worked by the committee. Senate Bill 34 would have created a 5-year sunset on all existing agency rules and regulations, and any new rules and regulations would have received a 5-year sunset. Basically, within the time period of the sunset, if agencies wanted to keep any of those rules and regulations, they would have to put them into statute. And then the bill received a hearing on January 26th, but was not worked by the committee. And then the last bill I will try to describe is kind of a complicated bill. So I asked Janet, if you could also help me out with the summary of this bill. It is House Bill 2066. So this is a bill that would shorten the period of time in which regulatory bodies are required to issue occupational credentials to military service members or military spouses seeking to establish residency in Kansas. And it would provide for the expedited credentialing of non-military prospective residents. And the bill requires licensing bodies to issue appropriate credentials to military service members or spouses within 15 days from the date of a submission of a complete application, or within 45 days for all other applicants. And it outlines a establishment of a probationary credentialing under certain circumstances, temporary permits under certain circumstances. It does grant ability to have temporary licenses during a state of emergency declared by the legislature. And this bill was passed by the House on a vote of 103 to 21. And I have received indication that the bill was scheduled for a hearing and has been assigned to the Senate Fed and State Affairs Committee. The hearing for this bill on the Senate side is scheduled for Thursday, March 11th. And this bill has been amended twice. It is based on a similar bill from last year, but it's my understanding the bill from last year really focused almost solely on military and military spouses, whereas this bill does have other items that would affect non-military members. So Jan, do you have anything else to add to this bill? Like I said, it has been amended twice. Some of the direction in the original bill said agencies shall do certain licensing in certain circumstances, and some of the amendments changed that to may. So I wondered if you could help clarify anything on this 2066.
That's a fairly good summary of it. I mean, this statute has been around for a long time, but it applied only to military service members and their spouses. It did not apply to anyone else. So consequently, the numbers were not that high. They tried this last year, but again, it was one of those bills that the legislature left because, closed everything down because of the pandemic. So it didn't get work, but it came back. But now what makes it a little bit more interesting is that they now have an applicant is the word they use. So it's military and the spouses or anyone who intends to establish residency in this state. So it's much broader. It could be anyone who has no connection whatsoever to the military. As David said, they did soften some of the language. It used to say that you shall license them, and now they have changed that to may. There is also some things that you are to do, like rules and regulations to evaluate applicants. So but it's under this particular statute, if it passes, rather than your licensing regulations. So if you look at toward the very end of it, when you look at subsection P, it says this is where though it switched from may to shall. It says each licensing body shall adopt rules and regulations necessary to implement it. So you would have to start working on regulations to get them into effect if this would pass, so that they would be effective upon the date of when this would pass. So you may have to, right now it's set to become effective when this is published, which just typically means that's July 1st, 2021. So that means you'd probably have to start working on temporary regulations, which at the same time, you also run permanent regulations. So that's one thing that would impact you. Under CAPA, which all your licensing acts are now under CAPA. If someone submits an application, you have 90 days after the submission of the complete application. So 90 days is a little bit more lenient to gather all the information up and evaluate it. What is different here is that the time has changed. Like it used to be for military service members and their spouses, you had 60 days. That's been cut down to 15 days. For everyone else, that would mean the people who intend to reside in Kansas, they've changed that to 45 days, which is half of what you have for the other applications under CAPA. So things would have to move much faster to get an order out. It also authorizes like a probationary license, so that if you can't get everything complete, then you do have to give them like a probationary license. It doesn't say how long that probationary status is, but you can revoke it if the information in the application is false. Once the probationary period expires, then they are automatically licensed for full practice. So there's just a lot of things in here, but basically you're still having to evaluate it under what would be applicable for licensure, say if they had applied for a regular license or a reciprocity license. So there is something that was kind of, that is new language too, that you might want to look at. This kind of would help because if you recall, we had practitioners in other states that were coming in and getting temporary permits to practice under the pandemic so they could use telemedicine to practice in Kansas. If you look at subsection N, which is a whole new provision, now they're saying that if a state of emergency is declared by the legislature, that you can grant a temporary license to practice in any profession if you determine that their credentials are sufficient to protect the health and public safety. So that is something new. I mean, that may be helpful if we ever get another pandemic that you could do, rather than doing those temporary permits that we had before. You could give them an emergency license, is what they're calling it. So
other than that, there's really no impact to our agency operations.
Biggest impact is you're going to have regulations, and you're going to have a much shorter time frame. Your time frame for everyone else is going to be cut down in half. You're going to, I think probably the first thing would be, they did not define what intends to reside in Kansas means. So that would probably be the first thing to tackle in your regulations. What kind of proof does that require? They signed a lease, they bought a house, they have accepted a job. That's unknown.
And it's across the board for all professions?
It's across the board. There's a kind of a little bit of, this is kind of unusual language. They did have some kind of new provision that had to do with, I believe, the Board of Healing Arts, but they still have to do it. It's just they have, if the person meets certain things. But if you look at subsection S, it says it applies to all licensing boards not excluded under Q, which is again, has to do with Board of Healing Arts, and then I guess also technical professions for engineers. And then they list them. So that's kind of unusual because it says including but not excluded. So I'm not sure. It looks like pretty much everyone. So yeah, it's usually you just list the ones who are excluded, and then those everyone else, if you're not in the exclusion list, then you have to comply. This is done a little bit different, but it looks like it's pretty much across the board.
So David, remind us the status of this. It's
Okay, so the original bill was amended and passed out of committee, and then it was amended further when it was heard on the House floor. It has, now that it has passed the House, it was assigned to the Senate Fed and State Affairs Committee. And over the weekend, I got a notification it's been scheduled for a hearing on Thursday, March 11th.
so it feels like we ought to weigh in on this. This is significant impacts to our annual.
I can tell you at the initial hearing on the House side, neutral testimony was provided by representatives of the Kansas Academy of Family Physicians, Kansas Department of Commerce, Kansas Medical Society, Kansas Real Estate Commission, Kansas Society of Professional Engineers, and the State Board of Healing Arts. And then opponent testimony was by the Board of Technical Professions. So some of the other regulatory bodies weighed in on the hearing on the House side. But if you would like me to draft any testimony on behalf of the board for the Senate hearing, I'd be happy to do that.
I will say that in the past, when they started doing these amendments, a lot of boards were reluctant to say anything that would be negative because it is, this particular statute is sort of labeled as a military thing. And now that, like I said, that's pretty much been expanded so that it doesn't have that limitation, but they're still afraid to say they're against it because it'll look like they're afraid of that they're against helping out the military families. But so if you have any comments, you need to probably be very specific in what they are to make sure that because I don't think it's the military people that we're so much opposed to. Even though it does cut down the time for the military to be licensed. I don't know, Leslie or someone might be able to answer how many of those applications you get a year. For most boards, the ones for military service people are usually pretty low so that they're not inundated with a lot of them that they can't handle. But it could be this other one where it's because people, rather than using the reciprocity statutes, could come into here so that if it can't be completed, that at least they're going to be getting a temporary license or a probationary license so that they can start practicing. There's a lot of moving parts to this.
We currently, in the past, we didn't have a way to track it, whether or not they were military. So I couldn't tell you the numbers.
If you don't have a special application for this, I don't think you would know unless they specifically tell you and say, I'm under this particular law, I'm military, and I want it to be addressed as that. So consequently, and this is something I talked with David, if this did pass, you may have to create a new application form so that you know that this is what they want rather than like the reciprocity statute. Otherwise, you may get complaints because there is in here a provision where every July 1st, the board has to make a report as to how many licenses have been requested and denied and given and that sort of thing. So the only way to track it would be to have a special application process.
I had a question, David. Do you recall the testimony, the opposition, the testimony from the opposition, what generally that was?
So in the supplemental note, it describes the neutral testimony as concerns about the lack of clarity in certain provisions of the bill and potential unintended consequences if the bill is amended. The opponent testimony by the Board of Technical Professions, they said that the bill would not adequately ensure public safety. And I can tell you, when it was amended in the House committee, so the Board of Technical Professions, or the Board of Healing Arts was given an exemption. Let me see.
That's the new section, I think. Is it P? No, R, which now R.
I'm just thinking if we formulate something, I don't want to be too far off base with what's out there already, I guess is why the reason I asked.
Yeah, so I heard some conversation, but I'm not sure if this is actually in the testimony or not. I know one of the concerns was in the expedited time frame for the licensing. And I understand that the Board of Technical Professions wanted to, in some cases, be exempt from some of the provisions of it. But I haven't had a chance to look through all the testimony on it, so I don't want to speak too broadly towards what might have been in there.
And I'm assuming what's in R is probably a result of that testimony, because it basically says that Board of Healing Arts and Technical Professions may deny an application for licensure or decline to grant a temporary or probationary license if the board determines the application's qualifications are not substantially equivalent to those established by the board. Such board shall not otherwise be exempt from the provisions of this act. So they didn't get a complete exemption.
Board think? Do we want David to provide testimony?
So that I'm clear, the temporary, we put language in about the temporary permitting and licensing in our bill. This particular one is the section I'm referencing is only under an emergency order. Is that right? Where we could issue this temporary license?
They have a probationary license and a emergency declaration. So the emergency declaration that it's what is now, it's on, well, when you print it off, it's on page 7, but it's under N as in Nancy. That is the emergency declaration. And that would be something different from when about giving them a probationary license. A probationary is under, I believe, H. Yeah, upon receiving a complete application, the licensing body shall ... give the applicant on a probationary basis, but may revoke the license, application, registration, or certification at any time if the application in the if the information in the application is found to be false. So, I mean, if it was true, but let's, if it was true, but the underlying, say it was about conduct, and they report that, but you want to, after you find out what the underlying conduct is, you may want to take away that license. I don't know. So you could use that to take it away because they didn't lie about it.
So I just want to throw this out for food for thought. On Wednesday, there was going to be a hearing, and that hearing was continued. So I had indicated to the board members to go ahead and plan to just have that time for a CAPA session. I don't know what your availability is as board members, but if you were available to meet prior to that, maybe at 9 o'clock the morning of the 10th, if you wanted to think about it between now and then, and if you were available to meet then, we could do a quick meeting of the board at 9 o'clock on the 10th, and you could give me direction on what testimony you'd like me to provide. If you want to tell me today, that's fine too. But since this bill was scheduled so quickly, if you want more of an opportunity to read through it and think about suggestions for the testimony, I just want to throw that out as an option since the board is planning to meet this Wednesday morning.
Well, I mean, I thank you for that suggestion. I think it's one that we should definitely entertain. If we were to meet as a board, and frankly, we need to circle back about SIPAC anyway, unless we wrap that up today. So I was already going to suggest another meeting, unfortunately, to move on that in a quick fashion. So I'm wondering, I guess, what was going through my mind. So I think we should, in my mind, we have a duty to explain how this bill will impact our agency operations. And that in essence, it's one thing to create a slightly different process for the military. It's another thing to basically kick open the barn door and say it's any applicant. I don't have a good understanding of why that change was made. So in essence, we're creating parallel processes and a lot of confusion. So I just think that those points need to be made. If we have specific amendments we'd like to see, then I think those should be included too. I won't pretend to be able to articulate that. I think that's something perhaps Jan and David could work on, some bullet points about what those changes that we would like to see if that bill, I'm a little nervous about this. This seems to be kind of sailing through. So I think it's our responsibility to explain how this is going to impact things. I just see a lot of confusion coming from this personally. So.
Yeah, I agree, Deb. And I would, I've looked through my email to make sure I didn't have that bill attached to read through it. I think it would be important for me to read through it because I want to understand, my mind's going to, yes, these types of probationary licenses, plus what we were putting in with temporary permits, plus SIPAC, like all these things are sort of flowing together for me. And so I think it'd be helpful for me to read that so that I could better articulate what I'm thinking.
Yes, I just noticed there's also a supplemental note on that, David. I imagine that's where you got some of this. That would be helpful, I think, to read that more thoroughly. I just skimmed it, but it's 10 pages alone, just the supplemental note. So I'm in favor of looking at this more. I think I agree with Deb, but we need to have some sort of a position on this because it does seem to kind of be going quickly.
Yeah, my apologies for not sending this one out. There were quite a few bills, so I was planning to summarize them. But yeah, you haven't received a copy of this one yet. Just one that I've been tracking. But since it passed the House and was almost immediately scheduled for hearing on the Senate side, I wanted to definitely speak to it today. But after the meeting, I'll go ahead and I'll send a copy of that out. And I'll send a copy of the supplemental note. And just to clarify, so when the bill is presented in its original form, there's not a supplemental note usually. And then if it's amended, there's a supplemental note. And then if it's amended further, there's a new version of the supplemental note. So I'll just go ahead and send the current version of the bill and the current supplemental note to go along with it.
I have a question, David, about the original Bsrb bill. You indicated that the section for reducing the number of hours required for social workers had been removed from the bill. Does that mean that the current standard will stay, or that the requirement for any face-to-face hours has been removed?
So the language in statute would require 350 direct contact hours as part of the practicum. And the board had recommended changing that from 350 to 200. The amendment that was made basically just strikes that section that requires a total number of hours. So with the way that the House and the Senate have amended the bill, it completely takes out the reference to a required number of direct client contact hours as part of that requirement.
And that's for social work only, correct?
Correct. That's correct. Yeah, because the bill also reduces the professional counselor hours from 350 to 280, and that wasn't changed by the committees. And I don't believe it changed for the other professions in the bill.
So does that mean essentially they could be licensed without any face-to-face hours?
I think I'm sorry, Dave. Go ahead.
Yeah. No, I was going to say Leslie might be able to weigh in on this more clearly. So that's perfect.
Just on cue.
The CSWE, the Council on Social Work Education, requires direct client contact in their practicum. It just doesn't specify. They have to meet certain criteria, but they do have to have direct client contact.
Which we knew. the problem is unaccredited schools, correct?
Unaccredited schools in the regulation for unaccredited schools, there is an hour requirement for practicum. And it could be changed to include direct client contact.
But that was our concern as a board in removing it, correct? Because we knew that's what stakeholders wanted.
Right. And I can say that honestly, there have been some BSW programs, maybe one or two, since I've worked here that didn't have CSWE accreditation. But really, unless it's in candidacy, we haven't had any that just are not accredited at all or in candidacy.
Okay. All right. So
I have a couple items left in the executive director's report, but I didn't want to cut short the discussion on the bills if you wanted to have any other.
yeah, I think at the end of the meeting today, we'll talk about potential dates. We may just direct you to send out a doodle poll, but to discuss not only that bill, but also the SIPAC bill.
Okay. I'll go ahead and I'll wrap up the executive director's report. Just a couple of quick items under other items. So most of my time this spring has been over at the Capitol or meeting with members of the legislature to work on our budget and work on the bills. But I have tried to become a little more familiar with some of the national organizations and associations. So on February 23rd, I was able to take part in the first day of a 2-day conference put on by the American Association of State Counseling Boards. And I was able to learn more about some of the multi-state compact concepts they're discussing in terms of professional counseling. They had some speakers weigh in on how states are handling some of the issues related to the COVID-19 pandemic. And then they weighed in on some of the general licensing processes. And the second day for that conference is going to be on March 26th. On March 4th, I was able to take part in a meeting with ASWB called Engaging with ASWB. They discussed that the impact of the pandemic in terms of their revenue going down last year because of less tests being provided. However, their expenses were also down. So year to date, so far, their test administration is up 14% higher than it was last year. So they're seeing a bounce back in terms of people, more people than last year taking the exam, even pre-pandemic time period. They indicated that they don't expect there to be a change in the exam fees, but they are working on a new version of the exam, hoping for an English version by 2025 and a French version by 2026. And then they outlined some of the processes they're going about in terms of collecting input and working on incorporating workforce data and some other items. On March 5th, I was able to have a Zoom meeting with representatives of the Oklahoma and Kansas Red Cross organizations. They provided information on a program for veterans called, they entitled it a Resiliency Program. This is focused on providing sort of mental health first aid training to assist veterans pre and post deployment and also the family of veterans. And after I spoke with them, I asked if they could forward some more of that information to me so that I could review it and learn more about that program. So they are planning to do that. And then in terms of upcoming speaking engagements, Leslie and I will be speaking to some professional counseling students from Mid-America Nazarene tomorrow evening at 7:30, and just telling them more about the BSRB's role in the licensing process, and then some issues concerning discipline that they should be aware of, and so they can be good practitioners when they receive their license. So that completes my report, and I get to cover a lot of ground. So if there's any questions, I'm happy to answer any questions on any of these items.
Thank you, David. Moving on to staff reports.
I don't have anything. Dave covered it.
Complaint Review Committee report. Is that you, Bruce?
What do you want me to do?
Complaint Review Committee report. Is
Oh,
up next.
okay. I thought that was at the end. Okay, sorry. You should all have a couple of printouts on what we've been doing in Complaint Review Committee. Actually, we're doing about the same. Things are starting to level out a little bit. We don't have that huge jump in cases that we've had in the past. The committee is a very hardworking committee, doing a lot of stuff. You'll see for February of 2021, there were 12 cases reviewed, 19 closed, for a total of 81 cases going. Just for your information, on this case, or I mean, the cases that came up, we did continue one case because it involved a criminal matter that is still actively being investigated. So instead of taking action, from the licensing thing, we decided to wait for resolution of the criminal case and see what happens there. And hopefully that would offer some guidance for us. And they give, breakdown of cases that we've received and have open and all this. And that. Are there any questions about the CRC and what we're doing?
Hearing any, Bruce?
Okay, great. Thanks.
Okay. We're moving on to professions reports. So psychology, is that where you, Rick?
Yeah, you've received our February report and we haven't met since that. And I think we're scheduled for next month. So I'll have a report for you at next meeting.
Thank you. Social work? Is that Andrea?
Good morning. We also have not met. We are scheduled to meet next week.
Okay, thank you. Professional counseling?
Good morning. Professional counseling met in February, and we spent our time doing the advisory committee members orientation, and it was very helpful. And so that's how we spent our time. That's the only thing we have to report. Thank you.
Master's level psychology?
Yes, we met on February 18th. Most of our meeting also spent in the advisory committee training. We also did have a brief discussion about whether or not we wanted to add a member, given that we had requested a member who had not been present for over a year be removed from our advisory committee. That's been tabled until our next meeting. And then we had a brief discussion of the Interstate Compact for Occupational Licensure. We meet next April 8th.
Okay. Marriage and family therapy?
We met in February and spent the majority of the time in our training and didn't leave much time for anything else. And so we're scheduled to meet in April.
Okay, thank you. Oh, addiction counseling, we met on March 5th. We also engaged in the training for board and advisory members. And our next meeting is June 18th. So we've done a couple things. We are going to move to quarterly meetings with the option to call on if we need it. And I've also done a review of the members. And I also came across a board governance policy, which probably we should talk about on a future meeting, that limits the terms to 8 years. It's 4 2-year terms on those committee members, which I don't think I ever knew about. So I think that involves one committee member that probably needs to roll off. But yeah, so that was it. I'm assuming there's no behavior analyst report. Okay. All All right, old business, records of deceased practitioners. I assume this is your agenda item, David, to report on?
And Deb, actually, so this was an item that was discussed by the board, I understand, in the fall. And I understand that it was a topic the board had requested some additional information. So I talked with Jan and asked if she could weigh in on this topic. And there's a couple of documents that were in your packet that were provided concerning, I think, records from Missouri and also records from another state as well. And I just wanted to see if Jan maybe could weigh in on the topic of records from deceased practitioners and just some overall sort of thoughts for the board in terms of maybe how, the disposition of these records or who maintains custody of them, different items related to that topic.
These particular ones, I didn't highlight them, and I looked at them a week or two ago with David. Basically, they do cover deceased records, but it's being able to disclose them to someone else. I think recently, it was back not too at the end of Max's tenure that someone was requesting help. I think to actually remove the deceased practitioner's records because they were in the office and they needed to be able to get them out so that they could rent it. I think it was a landlord or something. And I think we referred that in that situation, we referred them to the Kansas Attorney General's Office of Consumer Division, because that is something that they do handle about getting possession of those records and turning them over to someone who can take control of those and maintain them. And Jane might be able to speak a little bit about that. So it's kind of it was some of these provisions were in here basically for the court or for the board to consider if you wanted like any type of, you wouldn't be able to do regulations because it's not anything that a statute addresses. So it would be something more that, next time around for legislative amendments to decide if that's something that you think that you would want to address would be to who can disclose the records of a deceased person. Or if you think that's maybe perhaps already covered. Was there anything else that we discussed about these? I can't recall, David. I mean, there's two types of issues. One is the disclosure of the records of a deceased practitioner, and the other one, what do we do with the records of a deceased practitioner?
Yeah, I think we talked about, we wanted to follow up on this item since the board had discussed it in the fall. We wanted to give them a couple of examples from different states in terms of how those states handle some of these issues. So it may just, at this point, it may just be food for thought, information for the board members to review. But if there's anything else, I just wanted to make sure you were aware of these documents that were provided for your review.
So this may seem like an ignorant question. What is the guidance to an independent practitioner about records and what to do in the case of their death?
This is Rick. I know that the APA ethics code addresses that, but it's very generic, and it says that well, I can read it. Psychologists make plans in advance to facilitate the appropriate transfer of records and to protect the confidentiality of records and data in the event of the psychologist's withdrawal from position or practice. And I'm assuming that death would amount to the withdrawal from practice. I hope so.
They're out of your jurisdiction at once.
Yeah, that's right. You're not really technically a Kansas resident anymore, so. That was good, Jan.
So I suppose at some fundamental level, if a psychologist in the state failed to make plans for that, there could be an ethics charge brought against them and unethical conduct in the state. But that doesn't really help with what to do if someone has failed to do that and has died. So
those other states they give some sort of direction about that.
Jane, do you want to speak about what the consumer division does for the deceased practitioners' records when no one takes custody of them?
This is Jane Weiler, litigation counsel. I also will also add in the Board of Healing Arts in Kansas does have a statute that addresses this. So they were kind of unique. They would take possession of the actual documents, and then it's on their website as to where you would locate those if you had a medical record you were looking for. But as far as which is a call that I had, what Consumer Protection had contacted me, and it was based upon the deceased licensee. They will, because of the confidentiality of the records, they may take possession of them. The Attorney General's office, as far as the consumer protection, that's a whole different division. That's not my division. It's not Jan's division. But then they will make arrangements to try to get them secured with either release of information from the licensees involved or the clients involved, or trying to make some type of arrangement like that. And so it is something, and they do that for, I mean, more than just the records for a.
Welcome to the Conference Nation conferencing service. Enter your.
They will also
place you into your conference.
take the like nursing home records. They will take, I mean, they'll take veterinarian records. So it's not just the behavioral science licensees. If there are confidential records, they that's built into the Consumer Protection Act, and they will take possession of them if and get the release. I mean, they will try to contact the clients and get the documents to the client, and so that's where what their role is.
I might say I think I sent the Board of Healing Arts statute to David, but I think I did, but I can't promise that for sure. But one thing, that it's not that the board takes possession of that records, if I recall correctly. I think there's some kind of special committee that's set up, and they take possession of them and determine, where they should go and all of that. And then there's like fees associated with it or something. So it's a little different. It's not the board. It's in the Healing Arts Act, but it's a special committee that's been set up to handle the records.
Yeah.
So that would, to do it like the Board of Healing Arts, you'd have to go in and again, another statutory amendment the next time around to get that kind of same authority.
All right, board, what do we think? Is this a problem we need to solve?
I'm looking at just the quick overview of Texas, and it seems like something that we should provide some level of guidance on, and doesn't have to be next meeting, but it's something I think we need to continue to talk about, in my opinion.
Other thoughts? I guess when I held this topic up to the frame of public protection, this was kind of a no-brainer. And so it seems like while there may be some things in place, they feel like more of the net at the bottom of the cliff rather than helping licensees in particular understand their responsibilities.
I agree, Deb. Sorry, I agreed. And, there's private practice as well. So like with KDABs and their license, they have risk management for every private practice, but I don't think that's across the board. So I agree there. I think we owe it to our licensees to give them some guidance, like you said, and maybe think about this more and, what we would recommend as a board. I think that'd be a great idea to follow through on this.
So one of the things we haven't done very much of in recent time is convene subcommittee work on a topic that would pertain to all disciplines. We've kind of been operating just with our advisory committees. So this feels like it could potentially affect every discipline. So what do you guys think of that idea?
I can sort of see it both ways in my mind, that the BSRB should have a stance of whether that be public safety or professional documentation and record keeping. But I do, because those regulations are held in the subcommittees, I think it might deepen the conversation to have it specific to the discipline.
Okay, do you want to start there and see how far we get? Mary?
That works for me.
I just feel like at some point it's going to probably have to come back to that. But.
So you're suggesting start in the advisory committees, Deb? Did I understand that?
Yes, I mean, that was Mary's suggestion. I'm not married to it either way.
Okay.
And within the advisory meeting, if we wanted to have a subcommittee to look at that more thoroughly, we could do that, or, you know. Certainly we'll just begin the discussions, but that's what we usually do. You know,
right.
If it's a topic that we, you know, never seem to get around to, and sometimes there's a lot of those, so.
Yep.
It's good to know.
Okay, so we'll take those into our advisory committees and come back and report on it next month. Everyone's probably meeting. Well, my group isn't. But see where we get by the May meeting. Okay. Next item. Legislative History of Ksa 74-5374.
Okay, so as I mentioned earlier, at the last full board meeting back in January, one of the topics of discussion was KSA 74-5374, and that involves disclosure to a client, the end of a client-therapist relationship and documents. So I included sort of a summary document in your packet. It's a 3-page document that summarizes the history of that particular statute. I also wanted to let you know, in digging into the history on the statute, there was, so this is basically a statute that came into place back in 1999 with a 2000 date of implementation. I included the language of the official statute there. And some of the key parts of this disclosure are, if an individual, at the beginning of a relationship, you have to disclose if you have a master's degree or a doctoral degree. And if you have a doctoral degree, disclose if it's a doctor of medicine or some other doctoral degree. If it's not a medical degree, you should disclose if you are not authorized to practice medicine or surgery or not authorized to prescribe drugs. And there's some other items as well. In terms of the history of this, like I said, it came about in the 1999 legislative session. It was in House Bill 2213. And that bill was a pretty lengthy bill. It was the result of a task force that was recommended on behalf of the findings of the task force on providers of mental health services, which met over the 2018 legislative interim, and it was chaired by then Representative Phyllis Gilmore. The bill was brought to the House Health and Human Services Committee and had a hearing on February 17th. I was able to pull some testimony and documents from that meeting. That packet of testimony is fairly large, so that is on the BSRB website if you would like to review any of that after the meeting. At the hearing, there were a number of individuals who provided testimony, and the subcommittee was composed to study it further. This subcommittee brought back their recommendations on February 23rd, 1999, and there's also a packet of testimony from that meeting as well as a copy of amendments that were adopted when that bill was passed. The House went ahead and moved it forward, and it was passed on the House floor. It was assigned to the Senate Committee on Public Health and Welfare, and had a hearing on March 10th of 99. There's a packet for that date as well. And it was also assigned to a subcommittee. They came back and made recommendations on March 24th. There's a packet up there for that date as well. The meeting on March 24th was where the language in this statute really came into place. And the language in this statute was introduced by Ron Hine, testifying to the committee on behalf of the Mental Health Credentialing Coalition. And he briefed the committee on a balloon amendment, which was described as a compromise from proponents and opponents of the bill. And then there were 5 items, which are bullet pointed on page 2 of the document I prepared. The first item really addresses 74-5374, and it's just summarized there in terms of disclosures that all licensees under the BSRB are required to disclose information about their training, title, and abilities, and to document such disclosures to the client file. That's just a summary, but the language of the statute was a result of that balloon amendment that was put in when the Senate Public Health and Welfare worked the bill. The bill is a fairly large bill, as I mentioned, and below that I include the summary of the bill from the supplemental note, which was put together by the Kansas Legislative Research Department. A lot of other items in the bill have to do with some of the definitions of practicing under the professions, establishing a clinical level of practice for some of the professions, and then such as the disclosure items that were mentioned earlier, some of the references to the Diagnostic and Statistical Manual of Mental Disorders for social workers. So I went ahead and just summarized the items in the bill and wanted to give you a little bit of history on where that came from. And to the best of that I could find, it was through that compromise that was mentioned on the March 24th date. And since the time that it was put into statute back in 1999, there's been no amendments to that statute, updating it since that time. So just wanted to give you a little bit of the history of where that language originated and provide you some background if you wanted to read the minutes of those meetings or any of the testimony that was presented at those hearings.
Thank you for that, David. Very good overview of the history. I think the thing that, you know, is always nice to get and sometimes difficult in these situations is what was the intent. So we're probably not gonna guess. I mean, it's language. You know, hopefully the language is similar to the intent. I don't know. The language is not a bad thing, right? So, and I know you raised this question, David, as to whether this was still needed or desirable. And there was some discussion about, again, public protection, public information. I'm not sure what the board.
And Deb, I just wanted to mention one thing too. So this language, one of the unfortunate things about this language in terms of some of the testimony from back in those hearings is that, as I mentioned, there were those 4 dates, the 2 on the House side and the 2 on the Senate side. And this testimony was really introduced at that last date. So there are discussion points in some of the testimony as I was trying to sift through it. But since this item was added sort of in the last hearing date of the committee, it wasn't in the first version of the bill, which might have allowed individuals to directly reference it since it pops up right there towards the end. I'm not sure that there's a direct reference specifically to that language because of how late it entered the bill before it was passed. So just wanted to clarify that.
Okay. Any board comments? David, do you have anything you want to say?
Are you asking me?
Yes.
That's what happens when you have 2 Davids.
Oh, yes. I'll try to remember that.
No, we actually discussed this at our advisory committee, and the consensus of the group was they believed there continued to be good reason to do that. But I do appreciate the very thorough overview. Thank you.
Okay. Next item, regulatory language clarifications. I just want to remind the board that this topic has come up a couple of times, and we all have very different ways that we define this, unfortunately. The goal is to find compromise to have one definition for the sake of everyone involved with these issues. So Leslie has prepared, and I think it's in your packet, a couple of ideas. It would please the chair very much to take action on this today.
So the first thing in the supervision is I talked to Dave Phi and Joan because because of the pandemic, the face-to-face video conference supervision is very important, as well as the direct client contact being done in different ways. And so we felt like, we hope we can get something done so we can get the bills through for people who are going to start applying for a license. So all of the groups have agreed to or had similar language to this, and it's just the 1 to 15, 1 hour supervision to 15 hours of direct client contact with at least 2 sessions per month, one of which is individual. And then it would be, if our bill passes, it would be 50 hours of individual and 50 hours of group with no more than 6 supervisees. So the last time there was a lot of discussion, and this just seems to be, it was agreed to, the social workers had agreed to it a while back. And then, it's kind of changed since then. I know that, I'm not saying that they agreed to it now, but, and 3 of the professions already have the 1 to 15, just in a little bit different, quirks within that. So this would be hopefully universal for everyone.
So Leslie, at my direction, has provided you with a sample of what we consider to be kind of the best compromise, most clear definitions that hopefully we can agree on.
And then when you're done, I have one I want to talk to the board about 50 continuous minutes for an hour.
Questions for Leslie?
I don't have any questions. I just will reiterate, MFT advisory group was really pleased for the 2 half-hour sessions that sometimes just as a function of work life and meeting together. So I appreciate that addition in here. And I think this would, I think the advisory committee for MFT would be supportive of this.
Deb, are you asking us to take this back to our advisory committees?
No, we've already gotten, we've already discussed it from the advisory committee, and what we're just kind of lacking is an agreement on the words, and just move on.
Well, I think it looks pretty good. It's easy to read. It's simple, not very complicated, and I think it's good. Thank you, Leslie.
Thank you.
Leslie, question. This is Mary. I think the one thing that sticks in my mind is conversations, and I'm not trying to open a can of worms because I'm very happy with what this looks like. But one of the problem areas that we identified that we were trying to mitigate is the regularity, let's say the interval of supervision, because there was some, discrepancies around how people receive their supervision.
Mm-hmm.
Do you feel like if we make these language change, there's enough in here with the 1 to 15 that will take care of that problem?
I would hope so. I mean, if it would work better to say, I don't know, really, there's just no way to define it and make people able to understand what we want.
Yeah, this is Joan. And I look at these things every single day. Honest to goodness, no matter how clear you think you've made it, I promise you there's going to be somebody that doesn't get it. But I think an effort to clarify it and make it more streamlined will be a significant improvement.
There's usually always someone who becomes more creative in finding a way to interpret it. So you do the best you can.
Right.
Exactly.
And I think with saying 1 hour, you know, is 50 minutes, continuous 50 minutes, should help the people who think, well, I can have, you know, 5 little bitty sessions and meet the requirement.
Other discussion, questions? I would entertain a motion to approve this as written.
Before we do that, do we want to hear the issue on the continuous hour?
Two different.
Okay, as long as I wouldn't want to put forth a motion that would be changed by content of another definition.
Go ahead, Leslie.
So the hour in would an hour is used in the continuing education regulation and the post-grad regulation. And I would have to look, but I think that's the 2 main places. So I was asking Jan if we put it in definitions rather than in the post-grad because they're different. And she said, so the regulation would say the definition of an hour, and then for the postgraduate supervision regulation, it would say 50 minutes, 50 continuous minutes. And then for the CEU regulation, it would say 50 continuous minutes or whatever you guys decide. The problem is that in the CEU regulation, there's a difference between an hour depending on what you're doing. So there's, you know, a 50-minute hour and there's also a 60-minute hour. And I didn't know if it would make a huge difference if it was just one, if we could just say an hour is 50 minutes, or if that would be too much, take too much away from the continuing education.
My comment to Leslie was that I felt like that's pretty much how it happens in practice anyway.
Yeah,
Real life.
Yeah, this is Rick. My program is an APA approved sponsor of continuing education, and we operate on a 50-minute hour also. So it would have no effect on the programs that we put out. So it's just my thoughts.
I have a quick question, clarification on what Leslie wrote up. So under absent extenuating circumstances, it looks like there's part of that middle sentence that's in there twice.
Oh, I'm sorry.
And then in the next line, 1 continuous hour of clinical supervision for each 15 hours of direct client contact or 2 half-hour sessions. I'm assuming the 2 half-hour is related to the 1 continuous hour?
Yes. I apologize. And because I started writing it, trying to use a regulation, you know, like it was in a regulation, and everyone's is different. So then I just thought I'm going to bullet point. And the absent extenuating circumstances refers to telephonic supervision.
Yeah, I just think pulling the 2 half-hour up into the part
Yes.
where it says 1 continuous hour makes it a little less confusing.
Yes, I would do that. Yeah, thank you.
To read 1 continuous hour
Or
or
two half
two
hours.
half, yeah, and put those together, I would agree.
Yep.
So is the 2 half-hours, is that going to be where someone says 25 minutes
Yes.
to make it a total of 50? Okay.
Yeah, and that would be in the definition too.
Then we did decide on a definition for extenuating circumstances, I believe, as well, didn't we, Leslie?
Sort
That
of.
was discussed.
It was discussed. The language is in a regulation now, but it refers more to like you couldn't take the exam because you know your doctor said you shouldn't, and some of that I think would be
out of their control, basically.
right.
So we'll probably have to work on something then that would apply to more specifically to this, correct?
Yes. So then I can do language for your next meeting on extenuating circumstances.
Sounds good.
So the biggest question for you is if someone is if they're reading a book or, you know, doing an online training that doesn't have a post test, is that going to be an issue if it's only 50 minutes rather than 60 minutes?
I don't know why we would count an online training different than an in-person training. I don't understand.
Yeah. Some of them say it. That's why I just want to make sure.
I know. I just don't see the difference.
Well, yeah, I mean, you have to have breaks even if you're doing an online training.
Seems like we have a pretty good consensus. Not hearing a bunch of opposition.
I would just say my group wouldn't be real excited about this. However, I think with the addition of the language that says, you know, at least, it doesn't keep people from doing more than that. It's just kind of setting a place where you have to meet. So I'll sell that to them.
Thank you.
Yeah. I mean, this is Mary. I would move for us to approve the language as with the changes that David suggested earlier, just the sort of more grammatical type things in there. Right. But I would make that motion.
I second that. Oh.
Go ahead.
Carolyn seconds. Any discussion? All those in favor say aye.
Aye.
Aye. Is there any opposed? Hearing none. Well done, Leslie.
Thank you. Thank you.
Okay. New business. Disciplinary actions on agency website.
Okay, I'll go ahead and talk to this one. So on January 20th, I received an anonymous letter signed by Bsrb licensee. It appears to have been created on January 16th of 2021. And I understand some other board members also received a similar anonymous letter. This was an individual who was requesting help in modifying the Kansas Bsrb's board website policy concerning the publishing of disciplinary actions to the Bsrb website. They noted that they are a practitioner, and several years ago, they were subject to disciplinary action by the Bsrb and entered a consent agreement and order. They completed the requirements of the order, and the license is in good standing today. They apparently had done a Google search of their name, and according to them, the top result that came up was the disciplinary actions that were posted to the Bsrb website. In their letter, they noted that they're aware the disciplinary actions of licensed professionals are public records and subject to the Kansas Open Records Act. And potential employers, clients, and other interested parties have a right to request the information from the BSRB. However, what they were requesting in their letter was that it would take a formal written request to be submitted to the BSRB for them to obtain the full text of the disciplinary actions. And they noted that on the website, there is an open records policy, which outlines the process for obtaining records through the open records policy. There's also a document that concerns the board website policy. According to the letter, they indicated that it is their belief that the current practice for the postings on the board's website are not about transparency and access to public records, but they indicated they believe that it is about shame and embarrassment, and they expressed concern that it would be humiliating or disgusting to continue this practice, and that they were concerned about their friends or neighbors who might Google their name and find this information. They did include a document, which is also included in your packet, for the current board posting website policy. And they indicated in their letter that the online license verification tool will show a result of disciplinary action, yes. And what they are recommending and requesting is that we would note if there is a disciplinary action in the history of a licensee. And if there is, they would request the person go through the formal process to do an open records request on what type of disciplinary action and the details about that action. As I mentioned, there's also a document that was adopted in 2015, which has to do with the publication of disciplinary actions on the board's website. The policy was first adopted in February of 2002, but it was amended and adjusted later on in 2002 and also in 2008, and then most recently in July of 2015. The board's posting website policy indicates that the purpose of posting the information is to protect the public health, safety, and welfare and the citizens of Kansas concerning when allowing them to be of interest and informed when seriously disciplinary action has been taken by the board. So it describes what actions will be posted to the board's website and which ones will be not. It also indicates that the information will be posted to the board's website and that the policy is not intended to restrict the executive director or designee from appropriately responding to inquiries by the press or other persons or to lawful requests pursuant to the Kansas Open Records Act. And the policy, it's noted on the page, is effective for all disciplinary actions finalized after August 1st, 2015, and the previous policies are available concerning discipline before that and their process for being posted on the board's website. So I wanted to provide this document for the board and allow you to see the letter from the anonymous individual and also the board's current website policy for posting discipline. I also asked Jan if she would be able to weigh in concerning maybe legality or any legal issues concerning discipline posted to the board's website. And so I wanted to bring this to your attention.
As far as the legality is posting them, they are public records. So there's, as long as you redact what is protected information, there is no issue. Not as because it is to protect the public. That's one of the reasons it's up on the board website. Most agencies do have a way for people to get copies through their websites of the orders. Requiring individuals to make a core request, I think, could hinder protecting the public, because there is a process that goes through. One, they would have to send in a written request to do that. So it's more time consuming in that manner. But then once the request comes in, it goes to the information officer. They have to look at it and discern if they can figure out what it is, what records they are requesting. And Cindy and Leslie can attest to that is not always easy. So consequently, you may have to respond back and saying you need to clarify your request so that we can give you the documents you want. They have to respond back. Then in essence, you have to do a search for those records, which can be time consuming, copy them and redact them. Again, that takes time. And then under core, they can request that they will have to pay the fees and expenses for producing it. So that would include the time spent finding it, the time spent redacting it, the time spent copying it, and then the cost of postage to send it to them. So you're not protecting the public by requiring them to do a core request because it hinders their availability. So to say if someone was looking for a practitioner, but they wanted to make sure that they didn't have anything pending against them in the in the past, or that had to do with discipline, they may not be able to make that decision for several weeks down the road until they get a copy of whatever they requested through a core request. Whereas when they go on their website, they can get that information rather readily.
What do other boards do? Like Healing Arts, is it in perpetuity as well?
I believe it is.
This is Jane Weiler. I will address that. I do know with Healing Arts, it is in perpetuity. As far as for the Behavioral Science Board, we have in the past, we've had instances where some licensees have requested that it would be only posted for a set amount of time. And the Complaint Review Committee has reviewed those requests, and the Complaint Review Committee has denied those requests. That it goes to that and these are all orders that have been issued by the Complaint Review Committee, and the Complaint Review Committee recognizes that the board's mission is to protect the public, and as Jan has outlined, that maybe the instance isn't, the issue hasn't just occurred in the past year, maybe it occurred 5 years ago. As a consumer, I still might find that some reason that I would want to either have that individual as a therapist or not have them as a therapist based upon what were the underlying facts that brought them into the order. And then there's also just on that, another consideration is that if there's public disciplinary action, the National Practitioner Data Bank requires it to be, and that's by federal law, that it requires it to be, well, we have to post it to the National Practitioner Data Bank, which now that will always be available in perpetuity also there. But it also just for the board is that it is a mandatory requirement, and that not making it a public document, that is non-negotiable. That if it is related to the care of clients, it's a public document.
Our changes in 2015 were to match our reporting requirements or publishing requirements to the website to exactly match the database requirements. That's the amendments, the small amendments we made in 2015. That's what the amendment were, so that they match our the national reporting requirements.
And I'm glad, I was going to mention the National Data Bank, but that there are requirements that certain things be published. And so one way to do that is to put it on your website so that that way everyone can see it and know what happened.
We do not publish things that are not related to the practice.
Correct. That's what your policy says.
Now I have several other boards, and if there's a public action.
Let's just pause and see if there's any board reaction. And then we can go from there if we need more information.
I'm not certain why when she put it, she's saying that when she just put her name, it popped up versus seeing it publicly in our webpage. I was wondering how something like that would happen, or if it happens.
Pretty much anyone can do a search of your name, and anything that's been published is probably going to pop up. I mean, I can do a search of my name and find where it's been mentioned in Supreme Court opinions. So
I think the question is, why would it come up like as a top thing? And it could just be lack of traffic about that individual, or I don't know. Frankly, if it was me, I'd probably get with Google.
Probably algorithms, isn't it? That what puts things at the top.
and what people select. So if you do a search and that would suggest to me that there was a lot of traffic to that person's consent decree, which may be important. That, I mean, I obviously don't know who this was, but if it's coming up as the top hit instead of their practice, well, that may say something. I don't know.
And I don't know, but you're right, it goes to the top. And so maybe it's a possibility there's, you know, like in job searches, a lot of employers will Google search names and look people up on social media. So there's a lot that can be assumed, I guess.
I think the amount of time plays into it as well.
All dependent upon that website's algorithms.
The board feeling like there needs to be further discussion or any action taken?
I don't believe there should be any additional action taken. That's my feeling.
I agree.
I agree.
I agree.
Me too. I feel like our policy already kind of weeds out things that the public, you know, wouldn't necessarily be as harmed by. Obviously, this falls into the other category. So, and I think following what the Board of Healing Arts does is also appropriate for us in this case. Okay, next item is board member responsibilities if in receipt of message from the public.
And Deb, I just wanted to talk to this point for a second. So as I mentioned, I received this letter anonymously. We don't know who it was from. And it was also sent out to several members of the board. And Jan had recently done a training for board members, and I wasn't sure if this was a topic that was specifically addressed, but I thought it might be helpful for the board to have some input from Jan in terms of what their responsibilities might be if they should receive a letter from a member of the public, either anonymously or from a specific individual, or maybe some of the limitations or potentially, you know, dangers in responding to members of the public. And so just wanted to open the conversation and allow individuals, or see if Jan could weigh in with some thoughts on this topic in terms of what board members might be responsible for or not if they receive a letter from the public.
Well, the problem usually arises, I mean, if they want to speak, probably the response would be to advise them that, you know, they need to contact David so that they can, if they want to appear before the board. But you do not represent them, so you cannot speak on their behalf, because that's a lot of times what they want you to do. Would you please take this to the board and discuss it for me? And the answer to that should be, you know, I'm sorry, I represent the board and the public. I do not speak on your behalf. If you want the board to be made aware of this subject, then, you know, please contact David Fye about if you can be a part, you know, to make a public comment at the board's next meeting. And that's pretty much it. The really big issue that comes into mind is if, like David said, they sent this to several people. And I don't know if they meant through postal service or email, but a lot of times it does come through by email to several board members. And you have to be very careful, because if it's reached a majority and you all start responding and discussing it, then we may have a problem under Tacoma and have a violation. So that's typically why you don't want to respond by email. If it's in that regard, you may just want to send it to David and say, hey, would you tell this person that I can't help them and that they need to come to the board meeting. And that may be, rather than trying to start engaging with this person, you may just want to say, you know, send it to Dave and say, I received this. Would, you know, tell them that I can't represent them to make the board aware of their position. They'll have to come to the meeting. Any questions?
Yeah, I do have a question on phone calls where I think people reach out, you know, if they know you. I know you're a member of the BSRB, and here's my question. You know, if they're more informational, just here's who you should contact with the BSRB, that kind of thing. But what do we need to be aware of in those kind of conversations? Again, same thing. We can't speak on behalf of the board. But what's your advice on that?
Well, the problem is if something should arise where that would come before the board and you've had this conversation, is it enough to arise to an ex parte communication? So sometimes it's frustrating to people because they think that they can call a board member up and the board member will give them the answer to what they need to do. And you cannot do that. You're almost getting into giving out legal advice in that regard. So probably the best thing to do would be to say, again, I'm a board member and I can't help you. However, if you want to go to the board website, here's the website, you may want to look there because the statutes are there, the regulations for every profession are there. There's also FAQs that may help you. And again, you can direct them also like to David to say, if there's any procedures that are involved with the board, he can maybe help clarify those for you. That type of question. But, that's the bad part is if you start answering their questions, then you're going to hear, well, this is the way Mary told me to do it. And I just took Mary's advice. Now you're telling me it's wrong. That's one of the reasons not to get caught up in that.
So forwarding, for example, if we got an email from somebody who's got an issue, they know we're on the board, forwarding that concern on to David so as not to get kind of in the middle, that's an appropriate action.
Yeah, David is not a part of the board, so he is not caught up in Ksa. So talking back and forth with David isn't, as long as you don't have other board members involved, that's it. But you could just forward it and say, I received this. You may want to reach out to the person and explain that a board member cannot is not there to represent your interest. Rather, they're there to protect the public good. And if you want to speak to the board, then you need to come and speak directly on your own behalf. But that's why you can forward it to Dave, as long as you don't get all the other board members involved.
Okay, thank you for that. That was very good information. Optional training for new board members. David?
Yep, I just wanted to speak briefly to this. So the ASWB, the American Association of Social Work Boards, does put on a yearly training for new board members. And I understand they're going to be doing it a few times this year. I have not experienced this training, but I have heard that it is a good training for individuals who are new board members or ones who have been board members for some time. This year, they're doing some virtual trainings. The first ones that are coming up are on Thursday, March 25th and Friday, March 26th. And I just wanted to clarify, so these trainings are not specifically just for members representing social work. They're for members of boards. And they kind of, from what I understand, the training is broadly in terms of discipline and sanctions, current issues, delegation, rulemaking, conflicts of interest. So if you are interested in taking part in the trainings, each day of training is from noon to 4:30 on March 25th and 26th. And I understand that's coming up real soon. There's another opportunity to do these trainings, and that would be the same time periods, noon to 4:30 on June 10th and June 11th. I do not have an agenda for the breakout of the sessions those days, but these are free trainings. They're open to all board members. They would be virtual, like I said. So if you are interested in doing one or both days, either the March dates or the June dates, just go ahead and let me know, and I will contact ASWB and get the information for you, and I will go ahead and provide it to you. So I want to make you aware this is an opportunity that's available for you.
David, I'll just speak briefly. 2015, I attended that. Of course, in those days, they flew you there to their site, which was really cool, and paid your hotel and everything all free. And but it's a great training, and also a great opportunity to get CEUs as well. So I think it's a well worth conference.
And I want to let you know, I am planning to sit in on the trainings in March if I am able, as long as there's not a meeting that comes up for the legislature during that time. So if you want to ask me any questions about the training after the March date, if you were considering doing the June one, feel free to reach out after those dates.
Okay. So kind of circling back to the two items we discussed today that potentially need further action, especially for this legislative session. The bill we talked about for veterans and whoever else, and then also the SIPACT bill. So I guess David threw out 9 a.m. on Wednesday. I don't know if that works for the majority or we just need to send out a doodle poll. It works for me.
Works for me.
Yes.
Yep, I can do that.
I'm not
Can
going
as
to be
well.
able to do that, but I can do the 10 to 12, which would still be on, right?
Yes, yes,
Kappa.
absolutely. We have lots of Kappa to get through.
I have a previously scheduled meeting at 9 o'clock, so you can meet without me if you want, but I won't be able to be there.
I will be there. I can do it.
All right, so who can? Laura, Mary, Deb. Who else spoke up?
Jackie.
I can.
Leslie.
You know what?
I don't want to make this difficult, but I really feel like because it's about SIPAC, Rick's involvement in the meeting is sort of critical.
That's exactly what I was getting ready to say. Yeah.
We're on the wavelength, Deb.
We are.
Great.
Those
I'm
words
happy
were
to talk
starting
about
to
the other
trickle out of my
issue.
mouth. On second thought.
Yeah,
about
I'm happy to
after-
talk about the other issue so Dave can have prep time.
What about after the Kappa instead
Yeah,
of
that's what I was,
after?
yeah. I was going to suggest do the Kappa first.
Yeah, the only concern might be, so the hearing has been scheduled so quickly. It's
Oh,
going to
yeah.
be Thursday at 10:30. Now I can reach out to the chair and request that we can provide our testimony a little bit later than the committee rules allow. I don't know right now, but I could, after the meeting, if we don't have a time selected today, I could go ahead and send a doodle poll out with some times, maybe on Tuesday or on Wednesday, and then just kind of see what attendance everybody is able to do, if that would be helpful.
Let's do that.
But could I suggest that we do the 9 o'clock for David's issue with the testimony that's coming up Thursday and do SIPACT at a different time? I think there could be an hour's worth of discussion is my thinking. That's a pretty heavy bill that's being proposed. Just a thought.
Yeah, we've lost 2 board members already today. Danielle, are you able to join at 9? We just don't even have 7 yet, is all, Mary. Danielle?
Hello.
Hi.
Hello.
Are you able to
Okay.
join us 9 a.m. on Wednesday?
I am not. I'm available at 10 and on.
Okay.
Now, in terms of the SIPAC bill, I do not show anywhere that it has been scheduled for a hearing. So the urgency of the House Bill 2066 was because it was scheduled for this Thursday.
Yeah.
And the legislature is not having any meetings today and tomorrow. So this really was a fast-tracked hearing. Yeah, so I just want to let you know, if you want to have a different meeting for that discussion, that'd be fine. It's just 2066 to get that testimony in. That would be the one that would need the early meeting.
I don't have a majority at this point for 9 a.m.
Okay.
So.
I can go ahead and send the doodle poll out after the meeting and just gauge availability, and then
Okay.
I'll get back to you guys.
Great. All right. I would entertain a motion to adjourn.
So moved.
Second?
I second.
All in favor, say aye.
Hi.
Aye. Any opposed?
Aye.
All right. Thank you. Have a good day.
All right, you too.
Bye.
All righty. Bye-bye.